For decades, the English family justice system operated as an adversarial arena. To end a marriage, a party generally had to step into a courtroom and prove that their spouse was legally to blame for the breakdown. That system was largely replaced by the Dissolution and Separation Act 2020. This new legislation completely dismantled the strict requirements for fault-based litigation that had defined the process since the 1970s. Under the previous law, couples were often forced to make a strategic choice: formally accuse a spouse of adultery or unreasonable behavior, or wait for years of separation to prove the union was over. The current law removes those hurdles. It treats the end of a marriage as a matter of notification, shifting the court's role from investigation to administration. This shift is reflected in the statutory language. We no longer use the term petitioner, the party bringing a suit. Instead, they are simply the applicant. The decree nisi, which signaled the court's initial approval of the divorce, has been replaced by the conditional order. Finally, the decree absolute, the document that legally ends the marriage, is now known as the final order. In a departure from the traditional A versus B structure, couples can now submit a joint application. They approach the court as a unit to state that the marriage has ended. For the family practitioner, this changes the procedural starting point. While child and financial arrangements remain complex, the path to dissolving the marriage now relies on managing a precise statutory timeline. Before an application is issued, the practitioner must verify a specific procedural constraint, the absolute bar. Section 3 of the Matrimonial Causes Act and Section 41 of the Civil Partnership Act prohibit any application for divorce or dissolution within the first year of the relationship. There are no exceptions to this 12-month rule. Once that first year has passed, the applicant must establish the sole legal ground for divorce under the 2020 Act, that the marriage has irretrievably broken down. Previously, irretrievable breakdown wasn't enough. You had to prove it using one of 5 statutory facts, like adultery or separation. The 2020 Act abolished this requirement. Now the process begins with a simple statement of irretrievable breakdown. The court is required to accept this statement as conclusive evidence. No further proof of bad behavior or length of separation is necessary to satisfy the court. Because of this, it is now very difficult for a respondent to dispute a divorce. They are largely limited to technical defenses, such as challenging the court's jurisdiction or the validity of the marriage itself. As a result, practitioner focus often moves quickly past the divorce itself. Because the breakdown cannot be effectively contested, energy is redirected toward the parallel timeline for financial remedies. The new law replaces the friction of proving fault with a series of mandatory delays. This process begins when the D8 application is issued. For most practitioners, this is handled through the professional digital online portal managed by the court service. Issuing the application triggers a mandatory 20-week period. This is a minimum wait that cannot be bypassed. The legislative intent was to provide a window for reflection and a final opportunity for reconciliation before the legal status of the parties changes. For lawyers, this 20-week window is the primary time frame for the substantive work of the case, drafting and negotiating the financial consent orders and child arrangements. At the end of these 20 weeks, the applicant can apply for the conditional order to be pronounced. This order signifies that the court is satisfied the legal requirements are met, though the parties remain legally married at this stage. There is then a second mandatory wait, 6 weeks and 1 day. If the applicant does not move to the final stage within this window, the respondent can eventually apply themselves, though they must wait an additional 3 months to do so. Assuming the requirements are met, the court will then grant the final order. This order provides the definitive legal severance of the marriage or civil partnership. Mastering this 26-week minimal architecture is a core duty for practitioners. Any delay in hitting these statutory gates directly postpones the client's ability to achieve a clean financial break. What happens when a client needs immediate legal separation, but is barred by that 12-month waiting period? In these cases, the primary statutory alternative is judicial separation under Section 17 of the Matrimonial Causes Act. This process uses the same notification mechanics as a divorce. The applicant simply submits a statement that the relationship has broken down. Crucially, there is no 1-year bar for judicial separation. It can be applied on the very first day of marriage. The order legally terminates the obligation to live together. However, the marriage remains legally intact, Neither party is free to remarry. Some clients choose this route even after the first year, often due to religious or ideological objections to dissolving the legal union. Judicial separation makes the same financial and property orders available as a full divorce, allowing the court to divide assets between the parties. But because the marriage has not been dissolved, the court cannot grant pension-sharing orders. That specific remedy is unavailable. Advising on judicial separation requires balancing the client's immediate need for physical separation against the permanent limitations of an intact legal union. The 2020 Act has replaced the litigation of relationship breakdown with a statutory notification process. Removing the 5 facts has redirected practitioner energy away from drafting inflammatory allegations of behavior to secure a divorce. That energy is now focused on strict compliance with the court's digital portal and the rigid procedural milestones of the new law. The mandatory 20-week window is now the primary space for negotiating the financial and child arrangements that will protect the client after the divorce is final. Practitioners must also remain aware of alternatives like judicial separation to protect those who cannot or will not dissolve their marriages. Successful family practice now relies on using these rigid statutory gates as a framework to secure a client's independent future.